Good afternoon, everyone, and welcome to the Atlanta Press Club Loudermilk Young series. Today, we're doing an event on voter education, what's on the ballot 2020, an overview of the proposed constitutional amendments and referendums in Georgia's 2020 election. Today, our moderator will be Rahul Bali, news anchor from Oconee Radio Group. We also have Andy Welch, state representative from the Georgia legislature, Carrie Miller, a counsel at Robbins Law Firm, and Matthew Gamble, another state representative from Georgia legislature. And Rahul will be going over their bios with you in a second. First of all, I just want to welcome everyone. Thank you for joining us today. Thank you for supporting the Atlanta Press Club by being here. You may visit our website at atlantapressclub.org to find out what events we have coming up, to join as a member, to make a donation, or to sponsor us. So we'll get started, and I'll hand it over to our moderator, Rahul Bali. Welcome, Rahul.
Thank you, Christy, and good afternoon to everyone who's joined us, along with anyone who's going to be watching us recorded later. As Christy mentioned, I'm Rahul Bali, news anchor for Oconee Radio Group. I do the morning news for our stations in Milledgeville, Madison, Greensboro, and Eatonton. I've been involved with state capitol coverage on and off for more than 20 years. So I'll be introducing our guest in a moment. I did want to show you what we're doing. We're focusing on what comes at the end of the ballot. You know, there's tons of commercials and attention to what's at the top of the ballot: President of the United States, United States Senate. But if you look at the very end of the ballot, and what you're looking at is a sample ballot from Baldwin County, it finishes with 3 statewide ballot measures. In some other counties, you know, after that comes some local measures. So joining us to talk about these measures are their legislative sponsors and some other guests. So first, I'd like to welcome State Representative Andy Welch of McDonough. He is the legislative sponsor for both constitutional amendments. He represents District 110, which includes parts of Henry, Newton, and Butts County. He's the chairman of the House Appropriations Subcommittee on Public Safety, and he's a partner with the law firm of Smith, Welch, Webb, and White. Also joining us, Carrie Miller. He's counsel at Robbins Law Firm in Atlanta. He served in Governor Nathan Deal's administration from 2015 to 2019. This last year of that, the last year of that administration, he served in the position of executive counsel to Governor Deal. Now, what that means is he advises the governor on legal matters, legislation, and litigation, and you'll see why that's important as we get rolling here. Gentlemen, welcome to the Atlanta Press Club.
Thank you.
Thank you for having me.
So we're going to start with the constitutional amendment number 2, which deals with sovereign immunity. And right now I'm going to mute my phone too. Before we get into the amendment, Chairman Welch, can you explain to our audience what sovereign immunity is and why that's important?
So sovereign immunity is the legal doctrine that says, and it's actually a constitutional principle in state constitution, that says that the state cannot be brought into court and be sued in court without the state waiving its sovereign immunity. So it's immune from lawsuit unless the General Assembly or the Constitution provides a means to sue the state. It comes from an old English common law principle that the king could do no wrong. And so unless the king wanted to be held into court and sued, he could not, or she could not. But that is clearly, hopefully will change come November for the state of Georgia.
And in general, Chairman Welch, why is this needed? I mean, you know, we talk about soon, but kind of almost, why is this needed? Why specifically is this needed?
So historically, the state constitution has, back in the 1970s, then again in the 80s, and then again in the 90s, aspects of the Constitution have been amended to constitutionalize, or to write into the Constitution, the principle that the state is barred from being sued in the courts of the state. There was an exception for situations where an employee of the state or an officer of the state acted unlawfully without proper authority. That principle was revoked and reputed in a decision by the Supreme Court, referred to as the Sustainable Coast decision. And in that decision, the Supreme Court found that under our state constitution, the immunity of the state is not waived unless there's an express statute that says so. And in that case, there were environmental groups pursuing for relief, injunctive relief, a decision by the court to stop an activity done by the Department of Natural Resources. But the Supreme Court said that our Constitution does not allow for that, does not allow for that kind of relief unless the General Assembly adopts a law to authorize that lawsuit. From there, subsequent decisions were issued by the Supreme Court in a case called Oliveira. That case was a rejection of the lawsuit that could be brought through what's called a declaratory judgment action. And that means that someone could bring a lawsuit in court and ask the court to declare whether or not a specific act or decision by an official was unconstitutional or unlawful. And that decision came down where there was no such waiver in our laws. Followed up by a more recent decision in 2017, where the Supreme Court in Lathrop v. Deal said that there was no constitutional waiver of sovereign immunity for citizens to bring a suit asking for declarative and injunctive relief when a citizen thought that a government official was violating the state constitution. That last decision is really what triggered, I think, this particular constitutional amendment for the people of the state to consider.
So let's go ahead and read, and we're going to put this up on the screen for everybody. This is what's actually, well, if you've got an absentee ballot, you'll see this. This is what you're going to see when you go into the booth. Shall the Constitution of Georgia be amended to waive sovereign immunity and allow the people of Georgia to petition the Superior Court for relief of governmental actions done outside the scope of lawful authority or which violate the laws of this state, the Constitution of Georgia, or the Constitution of the United States? As the legislative sponsor, the lead sponsor on this bill, if this is passed, Chairman Welch, what changes for an everyday Georgian who has a beef with the government about a law, whether it's local, state? If they've got an issue, what changes? What becomes different for a Georgian if this passes?
This would open up the courthouses to allow for citizens to bring a suit against a local government or the state for a violation, what they perceive to be a violation of law, an action taken that's outside the scope of authority given to the official or a local government, or it could be that an action taken by a local government or the state that may be in violation of the state or federal constitution. This amendment would allow that suit to proceed against that local government or against the state. That's the primary function of it. There's a secondary benefit that I'll talk about a little later.
By the way, for those of you who are tuning in, if you've got questions, we've got a Q&A, we've got a chat. And there's actually a question for you from Amber Morgan, Chairman Welch, before we get to Carrie Miller. Was there a particular situation or a case that led you to do this?
Amber, that's a great question. And the answer is the Lathrop v. Deal decision. That decision had two aspects of it that I think caused me and other members of the House and the Senate to have concerns about bringing lawsuits in the state for unlawful activities by government officials. And that decision had three different holdings, but two that are important. One, it said that the provision of our state constitution that says that the courts of the state of Georgia are to review legislative actions and determine whether or not those actions are void, that provision actually did not authorize folks to bring a suit in court. And that caused us concern. We thought, well, this provision of the state constitution should allow for judicial review of legislative action or executive action. And because the Supreme Court found that it did not authorize those lawsuits, I felt it was important that we have a provision in our Constitution that that would allow for those lawsuits. The second aspect of that decision was that if you wanted to bring a lawsuit against an individual person acting in a government capacity, you would have to sue the person in his or her personal capacity, not the official capacity, or not against the state or against the local government. You'd have to sue that person in his or her personal capacity. And that has a negative impact, in fact, a chilling effect on people wanting to serve in public office if they could be subject personally to lawsuit and know that they would have to defend that lawsuit on their own, potentially. And so that concerned me in terms of having meaningful representation and incentivizing people to serve in a representative capacity or in an employment capacity with state or local governments. And so for those two central holdings of that decision, that sparked a lot of legislation, 3 bills that went through the House and the Senate, 2 of which were vetoed, and then finally this constitutional amendment that is now going to the people for a decision.
And we're going to talk about those 2 vetoes here in just a few seconds. Amber, thank you for your question. Sarah Campbell, I see your question. We'll get to in a moment, but I want to bring in Carrie Miller. Now, Carrie, similar legislation was passed by the General Assembly. It wasn't to the voters, it was sent to the governor. It was vetoed by the respective governors at the time, Governor Nathan Deal in 2018, Governor Brian Kemp in 2019. Carrie, you were the executive counsel to Governor Deal in 2018. Take us inside that decision to veto this kind of legislation.
Well, so, and just one clarifying point, and 2016 would have been the one that was vetoed by Governor Deal, and then 2018, Governor Deal actually challenged and created the Court Reform Council to propose its own concept for a waiver of state sovereign immunity. But, you know, I think it's important here, and in answering that question, Raul, to take a step back as to how we got here, and Chairman Welch kind of went through that briefly. You know, this is a concept that is a creature of the common law that follows from when the state of Georgia adopted the common law as its own law, the English common law as its own law, shortly after the founding of the state. Up until that, about 1974, sovereign immunity had remained a creature of the common law, such that a judge could alter the common law simply by having the case in front of them. You know, could read an exception into the common law, presumably supported by precedent, but you know, that assuming that could read these kind of exceptions in, which is how we got to the situation of the Supreme Court for years had been reading an exception into the concept of sovereign immunity in Georgia, such that declaratory judgments and injunctive relief, those kind of equitable actions weren't barred. After 1974, we adopted another constitution in 1983. That one again changed the sovereign immunity, the nature of the sovereign immunity provision, allowing it to be waived by operation if an agency just simply bought liability insurance. In 1991 is when the amendment, an amendment passed that changed the sovereign immunity provision to what we see today, what we see today prior to any constitutional amendment passing this time. And that's where one of the first cases to address it was a case called IBM versus Evans. And interestingly, in that case, Justice Benham dissented strongly from the majority opinion, which read back into the Constitution that exception. And Justice Benham said, look, the Constitution has changed since we did these prior acts. Looking at the pure text of the Constitution, that's just simply not what it says. So moving on until the Sustainable Coast decision, it had been interpreted in that manner such that it wasn't a waiver, it was an exception. And so part of the difficulty in this kind of quick action in 2016, shortly after Sustainable Coast, was that it was unclear as to where the law stood in Georgia. You know, frankly, we had just shifted from what folks had previously considered to be settled to a new statement of law that was accurate, but nonetheless was unclear where it was headed. And I also think, so that plays into a nature of it in terms of the unsettled ground that we were standing on. But I also throw in that, you know, that bill And frankly, I don't think it was any intention, but had some breadth to it in terms of, are we permitting suits over inaction? Are we permitting suits over retrospective action? Are we permitting suits not for monetary damages was the point, but is it going to be something that kind of bounds the hands of the policy making bodies, which are the General Assembly and the executive branch that enacts it? And frankly, it kind of leads to the question of, the role of our courts in some of these manners, and the way you see litigation going now is kind of a policy matter.
So first of all, Carrie, thanks for correcting the error that I made in our question. I wanted to go through a couple of kind of basic questions on this, and either one of you can answer, both don't have to answer. Does this have anything to do, I know again, we talked about people's constitutional rights. On this, does this have anything to do with, I don't know, suing a state agency for something like a car wreck with a government vehicle? Something like that. Does this change that process at all?
No.
No, and that's a good question, Ron, because it's a easily understood misconception, in that the state has already waived its immunity for tort actions via the Tort Claims Act. The state's waived its immunity in a number of other instances. And, I'd also posit that, to Chairman Welch's point, even after Lathrop v. Deal, there was a path, there still remains a path for the enforcement or for bringing an action for falling outside of the bounds of your authority, and that is the individual capacity suits that Chairman Welch mentioned.
Let me go to, and by the way, Sarah and Karen, I see your questions. I'll get to them in just a moment. One other question, and we're not trying to open the can of worms when it comes to coronavirus and state orders. But, there's been a lot of discussion about what state and local governments are doing in connection with coronavirus. If this amendment passes, does that in any way change, say, for instance, a business who feels like a local government has crossed the line, and how they can sue a local government like, the city of Milledgeville, which has passed some rules? That's one of the cities I cover. Does this change, and again, we're not talking about coronavirus in specific, but is that an example, and would that change if this passes? I'll start with you, Chairman Welch.
So this would only apply to actions that take effect after January 1st of 2021. So it would not, any existing ordinances or laws would not be impacted by this amendment. The act that would be subject, the action taken by a local government that would be subject to this would have to have occurred after the beginning of next year. But in the future, if a citizen believes that their constitutional rights have been violated by a local government, then they would be able to bring this lawsuit through this constitutional amendment to protect that right. There's a way to bring that suit another way. You can bring it in federal court, or you could bring it by suing each and every member of the city council or the board of commissioners or the office holders at the state level. But it is very difficult, you can imagine, to try to sue on a statute passed by the General Assembly, which has 256 members. And you have to bring that against them individually. So that creates a very cumbersome, but nevertheless an existing avenue. I think it's important to remember that this amendment does not authorize or does not call for damages, monetary damages, attorney's fees, or cost of litigation. That's not the purpose of this amendment. It is really just to protect rights. So there's not an incentive here to sue the state or sue local governments to try to generate attorney's fees or generate damages. The remedies are injunctive relief, which is to tell the government to stop doing something, and a declaration by a court that what was done or happening was violative, in violation of someone's constitutional or statutory rights.
So, Sarah, Carrie, real quick, did you want to add anything? Because I do want to follow up with what the chairman said.
Oh, no, go ahead. Yeah.
So I'm going to, Sarah, I'll get back to your question in a moment, because Elaine Sheridan has a question. in regards to this amendment, and it kind of follows up what you talked about, Chairman. Would the tax burden, her question is, would the tax burden on citizens of Georgia in order to cover the state's cost to defend itself in state court, and would this lead to substantial increase in court costs and filings?
Elaine, that's a good point to be concerned about. And oftentimes you hear the term sovereign immunity is also there to protect the purse of the state or the coffers of the state, or to protect the taxpayers as well. And while it has that function, I would ask you, and I would ask anyone, what's more valuable, my constitutional rights or the pennies of tax, the dollars of tax that are paid into the government? I would submit to you that protection of constitutional rights is paramount to any dollar figure. But to answer your question specifically, this again does not authorize the use of collection of attorney's fees or damages, unless the General Assembly in the future decides they want to do that. But right now it would not allow that to happen. There would have to be subsequent actions by the General Assembly in that regard. So it does, I think that what you would see is exactly what existed prior to Sustainable Coast, which is that there were lawsuits that were brought against state and local governments to correct unconstitutional actions or illegal actions done by state and local officials. Those suits dropped off after Sustainable Coast, and they would probably, some of them would come back. But again, I would ask that you consider, would you rather have that avenue to get there to prosecute and to defend your constitutional rights, or would you not? And is that a cost that we all should bear? We should allow for the public to have that access to the courts, to utilize the courts. And I think the answer should be yes. And let me follow up with one more point. In a constitutional democracy, it's important that the judiciary serve in the capacity of being a check on the power exercised by the executive branch or the legislative branch or our local governments, those creatures of the state. And if the doors of the courts are not open for that purpose, then they're not serving that check. They're not there to be that balance in that power structure that we've created in our Constitution. And that was the tragic part of the decision in Lathrop, to me, was that role of the courts was taken away, not by the decision of the court so much, but as written in the Constitution. And therefore this Constitution had to be amended to correct that imbalance. Along those lines, Earl, I think this particular interplay, and this goes back to what Carrie was saying a minute ago, was that Carrie was talking about the history of this. But I think this is a magnificent example of how the Constitution works for the state. The people wrote into the Constitution language that the Supreme Court then read and stated, that Justice Benham stated, and subsequently in 2015, I think it was, stated in Sustainable Coast, that our Constitution has a sovereign immunity that can only be waived by the act of the General Assembly or a constitutional amendment. And now what has happened is that the General Assembly has spent the last, I think, 5 years working on bills to waive that immunity for these two very limited purposes. And as a result, and the executive branch has weighed in on that in terms of vetoes. At this point, what has happened now is the General Assembly has submitted to the people a constitutional amendment that would provide for that opportunity to use the courts as a balance on the, or a check on the powers of the executive and legislative branch. To me, that's an awesome reflection of how our government should work. It should be slow, methodical, but each and every section of the government should play a role as a check and balance. The courts, the Constitution, the executive, the legislative branch, and now the people will be able to make that decision for themselves.
Elaine, thank you for your question. For those of you just joining us, I'm Raul Valley. This is the Atlanta Press Club discussion on the constitutional amendments and the referendum on the November ballot. Carrie, this next question comes from Sarah Campbell. Does the sovereign immunity affect cases in which plaintiffs have standings? I've certainly covered many cases in which people sued local governments. So if you want to go ahead and answer that question, and also answer that question kind of in reference to what this amendment would do also.
I'm glad you pointed out that question, Raul. I just saw it pop up on my screen, and it's an important one. And so that the concept of standing for, I know we've got non-lawyers on the call, and frankly, this sovereign immunity will bore even lawyers to tears, like few other things will do. But it's an important question. And so the concept of standing, as a matter of federal court, is rooted in the U.S. Constitution to say there has to be a case or controversy. You have to have an injury, in fact. It has to be redressable to the person you're suing, and the conduct traceable to the person as well. And so what that brings us to is that not every person who has a thought about what the proper policy should be has standing to bring a lawsuit, at least in federal court. Now, in state court, where this amendment will mostly apply, state courts, as a general matter, are courts of general jurisdiction and are limited by the state constitutions put forth and statutes in the Civil Practice Act. To be quite truthful with you, there is a dearth of standing precedent in state law as it stands now. And I think it's an important question in terms of this concept, because as Chairman Welch mentioned earlier about trying to sue to block, say, an ordinance from a local government. I think as a matter of efficiency, most, if not all of us would agree that not every person who disagrees with a policy that's enacted should have standing to bring it to court and force a judge to make a decision on it. Instead, you have to have an enforcement of that action such that it deprives you of some other right. And so that, I think, is a significant point as to the pre-constitutional amendment, how you go about this. And the lawsuit wouldn't necessarily have to be brought against every member of the General Assembly, but instead against the executive branch official who is enforcing it against you. And so in the concept of so to answer Sarah's question, yes, it will affect those who have standing. I think the intent of the constitutional amendment is such that you can't have independent standing to bring a claim just solely because you disagree with it, right, that you would have to meet other standing requirements. But the reality is some of that, again, is quite unsettled. And then finally, one point that came out earlier that Chairman Welch mentioned regarding localities.
Please go ahead.
I think it's an important point here in terms of where localities stand in relation to this. You've got a lot of Supreme Court precedent that treats a county as being a political subdivision of the state and part of the state's immunity. Compare that with a municipality that has its own separate provisions governing its immunity, its official immunity, and which explicitly says can be waived by any action of the General Assembly. Those come into tension because, frankly, in the concept of municipalities and a lot of local governments, our courts haven't had the opportunity to be clear about what the source of this law is. In fact, just last year, there was a case called Wino v. Lowndes County. And in that case, there were some excellent briefs put forward by the GMA, Georgia Municipal Association, and the Attorney General's Office as an amicus at the request of the court, really kind of laying out where this inconsistency is in precedent. And unfortunately, we still don't really have a guiding light as to that aspect because the court didn't need to reach it. And even in a concurrence, Justice Namias essentially acknowledges, I realize you guys are looking for an answer to this, but I can't give it to you in this case. So to circle all that back, it's important that in the context of a sovereign immunity claim, there must be a grounding or a hook in other legal authority, or I shouldn't say sovereign immunity claim, a claim that will run into sovereign immunity as a defense. And that in and of itself, my mistake there is why that's a problem. You can't necessarily have just a claim on any basis, in which case that tax burden, which burden on the taxpayers, which surely will increase some, could skyrocket. And frankly, it's a matter of what are the courts there to do. They're not the policy-making bodies; they're the adjudicating bodies.
So we now have a stack of questions here. So I'm gonna bounce them real quick. I know for Benjamin, I don't know if you tuned in a few minutes late. We did talk about some of the potential negative consequences to the amendment. We had a question about fee. What this could cost. Real quick, because we have gone so far over time, is there any significant opposition you guys know of on this amendment?
No, the amendment passed unanimously in both the Senate and the House, 164-0 in the House and 50-0. And I would like to recognize that John Kennedy, Senator Kennedy, was the sponsor of the measure in the House and the Senate. So it has gone through a long process of refinement to address a lot of the concerns that I think were legitimately raised by former Governor Deal and then current Governor Kemp. And so we've refined this measure, trying to address their concerns. And it does have a provision in it to maintain the existing rules on standing. So we did include that in this amendment so that those concepts, legal concepts, would remain in effect and in place.
I really do want to wrap this up. This has been a great conversation. For either one of you gentlemen, there's got another question from Melissa. In one sentence, what is the most compelling reason to vote for this amendment?
Gary, you want to take that one?
Well, you know, I think I think the most compelling reason is the concept of this, you know, private individuals being named in suit. It is a real concept in terms of they've stepped out of the cloak of their governmental authority under the old concept, but it's not necessarily the best policy to encourage people to serve. So I think that is a great point. You know, frankly, if I had my druthers, I think there would be I'd like to make some tweaks, but you know, that's the beauty of me not being in the governor's office anymore. You know, and I commend Chairman Welch for his work. And, you know, frankly, this is something that we've gotten close to the finish line a number of times and just haven't been able to get it across.
Yeah, I think if you want the courthouse.
Go ahead.
I was going to say, I think if you want access to your state courts in order to bring a legitimate claim for violation of your rights, then this is an amendment that you want to support. And I think it will make it a lot easier, streamline it for both the state, local governments, and then the individuals bringing those claims to get there and have those claims heard and decided by the courts.
And on that note, I want to thank Carrie Miller. Thank you so much for your knowledge, and thank you so much for your time and sharing it. This is a quick 30-minute discussion on sovereign immunity. Thank you so much, Carrie.
Thank you for having me.
Thank you, Gary.
Representative Andy Welch, you're going to stay with us because you are actually also the sponsor of Constitutional Amendment number 1. You were the sponsor of it in the General Assembly. We should mention that State Representative Jay Powell was the original lead sponsor of this bill that deals with how Georgia deals with state fees and state taxes. I know that, and this is not going to come as a surprise to anybody at the Capitol, I had a few colorful conversations with Jay Powell about this topic. Unfortunately, he passed away in December. And that led you, Chairman Welch, to kind of pick up the ball. And while you were a sponsor on the bill, you were kind of the person to keep it moving forward. Tell our audience why you were kind of the person to pick it up and keep moving it forward and get it onto the ballot.
Rael, this amendment also has a long history to it. The former chairman, Jay Powell, who passed away last year, earlier this year, he passed away last year, and he was working very diligently on the concept that when the General Assembly enacts a tax or a fee, that tax or fee, when it is stated to the public that it's supposed to be used for a particular purpose, that it actually be used for that purpose. Our Constitution, however, says that we can't dedicate revenues for a particular purpose unless we do it by a constitutional amendment. And there are a lot of them. Over time, we have adopted constitutional amendments to provide for a workers' compensation trust fund, a seed capital fund, which is actually for technology and development, not to be confused with the emerging crops fund, which is for development of crops. We have the safe harbor Rachel's fund that was recently adopted by the people of the state of Georgia. There's a long list. However, things like hazardous waste Trust Fund or the Solid Waste Trust Fund. Those are not on the those are not dedicated constitutionally. They're only written in the code. What this amendment does is allow us to actually dedicate those funds in the General Assembly without having to come back to the voters every time someone wants to dedicate certain revenues to a particular purpose. Here, Rahil has got a slide that shows you the fees collected over the last decade for the $1 tire fee that you pay when you buy a tire. Those dollars go into the general fund, and then you can see how much is collected by the blue line. Since 2010, it's been over 6 million, all the way over $7 million. And then how much has actually been dedicated or appropriated is in the red line. And you'll see that over time, the red line has been much lower than the actual revenues brought in.
Yeah, and let me jump in here. The red line represents the whole point of that $1 fee was it was going to be used for cleanup.
Yes, cleanup, enforcement actions, inspections. For tires that had long played, people will dump tires on the side of the road. They'll collect them, and then the business goes into bankruptcy, and you're left with a large tire pile that needs to be cleaned up. So those revenues were not being used to tackle that problem. Not incompletely, but not to the full extent that the $1 levy has been collected. So this amendment would then allow the General Assembly to vote to dedicate the Solid Waste Trust Fund fee, the tire fee, for that particular purpose. Joshua's Law is another one where DUIs, the folks convicted of a DUI are supposed to pay in a fee to the state, which is then used to help with driver education. Joshua's Law has brought in over $90 million since its existence, and a fraction of that has actually gone towards driver education. That is not a dedicated fee, but this amendment would then allow the General Assembly to dedicate those fees without having to come back to the people every 2 years with a constitutional question to be voted on. We should do these things internally. If we commit to you that the fee is going to be used to clean up tires or educate people on driver education, then certainly we ought to be able to dedicate that money for that purpose.
So I'm going to go ahead and put on the screen. This is the amendment as it appears on people's ballots. Shall the Constitution of Georgia be amended as to authorize the General Assembly to dedicate revenues derived from fees like the tire fee to a public purpose for which such fees, I can't say that, or taxes were intended. So let's start off with this. For example, the tire fee. If voters pass this, does anything change with the $1 tire fee and making sure that instead of going to the general fund or to other purposes, would it automatically make the money for the tire fee go to tire cleanup and the purposes it was intended to, fees that already exist?
That's a great question, and the answer is no. It just allows the General Assembly to take that issue up next session. So next session or any subsequent session, the General Assembly could entertain a bill to amend that tire fee to reference this new constitutional provision and then dedicate that money for the intended purpose. And once it's dedicated, it would be locked in for up to 10 years for that purpose. And we have built into this constitutional amendment, and part of the reason why it took so long to work its way through the system, through that process, was because there were legitimate concerns about this ballooning and dedicating fees beyond the capacity of our revenues. And we put in a 1% cap. So the maximum amount of dedicated fees under this particular amendment cannot exceed 1% of the last year's overall state budget, which was about $250 million. That's 1%. So next year, those kind of fees like Joshua's Law or the tire fee would need to be amended. The law would need to be amended to dedicate them pursuant to this new constitutional provision if the people voted in.
So I just want to tell anyone who's just joining us, I'm Raul Balley. This is the Atlanta Press Club discussion of constitutional amendments and referendums on the ballot. We're talking about constitutional amendment number 1, which deals with the state fees and taxes you pay and then what the legislature does with it. There are 2 questions that come out of the answer you just gave. So does this change the process for new fees in the future? For example, I want to come up with, a $1 fee for makeup, and then that will be used for cleaning up bathrooms. Very kind of, this is random, but if I wanted to start a new fee, would that fee now have to go to the voters, or does it now will be just in the hands of lawmakers?
So it would be in the hands of law. It can go either way. So we haven't disposed of the old way that you would actually present that as a constitutional amendment and then submit that to the voters. That is still there. That avenue still exists. This would allow, instead of that process, which has a pretty high bar, instead of that process, it would allow us to dedicate it internally. Another idea that has come up is there was some discussion about taxing plastic bags. Like a local government on the coast may want to tax plastic bags to try to protect sea turtles. That example had been floated around the General Assembly. If that was the case, then revenues could be dedicated to clean up the coastal environments from trash, and then and also help with the propagation of sea turtles or the wildlife along the coast. If we could, under this amendment, the General Assembly could dedicate that in the bill, and we would not have to go back to the people to make that request. Now, of course, it has a sunset in it, which means it's always going to come back for renewal, because think about it, if you collect so much money and you're not spending it effectively and you've cleaned up the coast significantly, you may not need that much money anymore, and it may be time to reduce that fee. If you do it by a constitutional amendment, all the fees that are built into the Constitution, those are fixed, and they're always dedicated, whereby the people can never go back and pull that money back or undo that fee or undo that trust unless you amend the Constitution to strike it, which would be almost impossible.
So I'm trying to wrap this up real quick. You talk about a high bar. Just one real quick question on that. Constitutional amendments have to pass by a 2/3 vote in the House and the Senate. Is that still the bar if it's passed by the legislature?
That is the same bar that's used in this bill, because we felt like we wanted to be consistent with that precedent to ensure that we thought through what fees we wanted to dedicate and to what purpose we wanted to dedicate them.
Final question. You sit on House Appropriations Committee. You guys had a very interesting year this year. You've had a very interesting looking at the budget and cutting the budget. It's been a while since we were, for those of us covering it, or you down there cutting the budget, and you chair the Appropriations Subcommittee on Public Safety, and you address some of this, but in any way, do you feel like that this, yes, the fees were going not where they were intended, they were going to the general fund. Any concern that this complicates the budget process?
No, to be honest, it will complicate it just slightly for that 1%, maximum 1% that could be dedicated. But remember, we've been dedicating significant portions of those revenues and fees, but not all of it. And so now we have an opportunity to keep that commitment to dedicate all or portion of the fee to the use it's intended. What it does do is it does create a little bit more a level of trustworthiness with our constituents, but it will take a little bit of money out of our hands that we would otherwise be spending to subsidize some other service that is needed and that is important.
State Representative Andy Welch, thank you so much for your time and your wealth of knowledge today. I really appreciate it, and thank you.
Rahul, thank you so much.
And thanks for joining the Atlanta Press Club. Let's get to the final ballot measure that people will be voting on. And joining us to discuss that, State Representative Matthew Gamble of Cartersville, who represents the 15th House District, which includes parts of Bartow County. He's a member of the Georgia House Economic Development and Tourism Committee. Representative, welcome to the Atlanta Press Club.
Well, thank you, Raul. It's good to be with you today.
Sorry we get to you a few minutes late. Our first two discussions got pretty in-depth, and we'll hopefully do the same here in the time we have. Before we get into this is a state referendum dealing with property tax exemptions for charities. What brought you to this legislation?
Well, Raul, I had recently been elected. I just have finished up what will be my first term as a member of the Georgia House of Representatives. And through a lot of experience prior to that in my profession and working around the state in education, I realized that we had an affordable housing issue statewide. It doesn't matter where you're at in whichever county you live. You are aware that providing more opportunities from an affordable housing standpoint is something that we all should be paying close attention to. And so I have the great fortune to sit next to Representative Spencer Fry in the legislature. He works for Habitat for Humanity over in the Athens-Clarke County area. He's a friend of mine, and we were talking, and so the opportunity came along to actually do something to try and help in a small way. And so that's what ultimately led me to passing House Bill 344 and the governor signing it.
So we have the amendment up on the screen. I'll read it really fast. It's really long. Shall the act, and this is what's on the ballot, shall the act be approved, which provides an exemption from ad valorem taxes for all real property owned by a purely public charity. We'll talk about that line here in a moment. As such charity is exempt from taxation under Section 501c3 of the Federal Internal Revenue Code. Such real property is held exclusively for the purpose of building or repairing a single-family home to be financed as such the charity to individuals using loans that shall not bear interest. Let's put this, the house that I'm sitting in right now, and I decide I want to donate this house to Habitat for Humanity. What happens to my house? What happens in terms of a local government?
Sure. Well, I think that what this addresses is more or less vacant lots and not homes that are already constructed. So in order to qualify, you would have to be an organization that meets the definition of 501c3 nonprofit and go through the process to be one of those. And then also finance homes for individuals at 0% interest bearing loans. So the primary organization that comes to mind when you think of the players in the space is Habitat for Humanity. And during the Great Recession, there were a lot of individuals who, for whatever reason, maybe they built houses or whatnot. They had surplus lots that were not being built on at the time. And so there were some cases around the state where Habitat had lots donated to them, which they graciously accepted. They realized soon that those lots come with the price, of course, of paying property tax. Keep in mind, this is on a vacant lot, so the tax is going to be relatively low compared to a lot that has a home on it and would be taxed at fair market value. And so in an effort to try and give Habitat and any organization that meets the definitions in this the opportunity to stretch their dollars further to build more affordable housing, we felt like this was a great opportunity to do that so that those lots would be exempted from ad valorem property tax until at which time a home is constructed and deeded over to the individual. And at that time, it would then be taxed at fair market value, just like anyone's home is at this point.
Any concerns? So you mentioned Habitat for Humanity. I always, as a reporter, think about the law of unintended consequences. Concerns about people gaming or cheating the system, whether it's the people who own the vacant lots or somebody sets up a charity, and you talk about that up here. It's kind of defined both in that and then more importantly in the legislation, the larger House resolution. Are you worried about people gaming or cheating the system on one side or the other to get out of property taxes?
Certainly, this was discussed in the hearings that we had on this bill with the Finance Committee in the Senate and the Ways and Means Committee in the House. All the attorneys that took a look at this, in addition to ACCG, GMA, and even the Georgia Association of Tax Officials. So it ran through the eye of the needle before it passed. But I would say that there is a clawback provision in the referendum that if the organization has the lot and they do not build the home, and they decide they want to sell the lot. So let's just say Habitat has 5 lots they want to sell rather than constructing homes on them. there's a clawback provision that would require them to pay retroactive property tax on that lot should they decide not to construct a home and to sell that lot. So there are mechanisms in place in this that will prevent what we feel like prevent unscrupulous players in this space. And again, with the whole goal intended to be stretching the dollars further to provide affordable housing statewide.
You know, a question that just popped up in my head, where's the enforcement? Would this fall under the Attorney General's office? Would this fall under the local governments?
Certainly the Attorney General could potentially be involved, but the conversations to this point have been that most local tax commissioners are aware of these types of situations working in their communities. And I do want to remind you that not every Habitat affiliate statewide or even the counties that they operate in currently has this scenario, but there are quite a few that do have these lots in inventory that it would help. But the local tax commissioners would have the ability to enforce and make sure that everything meets the criteria of this law.
This exemption involves county, local property taxes, correct?
Correct.
Is there a concern, and whether it's talking to, you know, ACCG or Georgia Municipal Association, were any concerns raised on at least a short-term drop in property taxes and the money coming into governments?
Certainly that is something that was discussed. And if you think about, again, a vacant lot and the current property taxes assessed on that, let's just say that it's $400, $500, $600 a year. If you exempt that for a period of time and then at some point have a home that is constructed on that lot and an individual living in that home, and then that home is now taxed at the fair market value, you would certainly be getting more out of that lot than you are right now with it being a vacant lot. So yes, in the temporary scenario, there would be a loss of some revenue there, but it would be realized and added to at the point a home was constructed and it was deeded over to the homeowner.
I have other questions, but we've got tons of questions coming in, so we'll go through these. Amber Morgan, why was this proposed as a referendum and not just passed through the legislature?
Well, we had to do that in order for it to apply statewide, and that was the decision that we decided that we had to go by. So that was why it was not a local bill since it applied to all 159 counties. Normally, if we do something like this, say for a senior property tax exemption, that would be local legislation that a county's legislative delegation would propose. But because this affects all 159 counties, this was the requirement, the threshold that we had to do.
We kind of talked about this, but let's expound on this. Benjamin Kaywood has a question. Could you clarify the term purely public charity, which is in the language?
Mm-hmm. Again, that would be a 501c3 nonprofit organization. And in the case of Habitat for Humanity, exists to construct homes, affordable homes for individuals who, again, meet their criteria, and then finance those homes at 0% interest loans. So if you, number one, don't meet the definition of a 501c3, and number two, you don't finance the home at a 0% interest or non-bearing percentage loan, then you don't meet the criteria in order to qualify for this exemption.
Got a great question from Mary Ann. This actually came up when you and I were talking about this bill when we were working through the cobwebs. On the legislative site, it still says in the title, not in the actual bill, but in the title, the legislative site says this deals with ticket sales. Can you quickly explain why the bill, the actual bill that's listed on the website looks a little different from the title that's at the top?
Right, that's a good question as well. When I initially filed House Bill 344, it started out as a continuation for the sales tax exemption for art institutions. That was an issue that I was interested in here locally because if for any of you that have been to Cartersville, Bartow County, where I live, we have the Booth Western Art Museum and the Tellus Science Museum. And so we were trying to get an extension for that. That was ultimately declared to be something that would not be supported in 2019 just because of where we were at from a financial standpoint as a state. And so in talking with Spencer, Representative Fry, and other legislative leaders about, okay, what could be something else that we could potentially do, that's where this issue came along. And again, it fit right within my wheelhouse as far as wanting to make a mark or do something to address the affordable housing concern in the state. And so that's when we substituted into House Bill 344 the language that we now have. So if you click the link on that website for the bill as passed, you will see the language that deals with ultimately what's on your ballot. But there is still confusion because the header is still confusing, saying that what the original 344 did.
We those of us who are down at the Capitol, we play this shell game sometimes of, okay, what bill is actually in here? So always my suggestion is click on the PDF, and you'll see what the actual bill that's being considered by lawmakers. I'm going to try to squeeze in one more question from Kathleen Kaysen. For Amendment 3, are there organizations that could take advantage by renting the property without paying property tax?
Well, no, because again, the caveat is that the lot has to have a home built on it, and it has to be deeded over to a homeowner to qualify for this. So if you're renting, you're not giving someone an actual deed, so it would not apply to that scenario.
I want to give you the final word as we wrap up here. Give someone a reason, they're going to be voting for president, Senate, Congress, state representative, Senate, and they get down, depending on their county, it's the last 3 things or one of the last 4 or 5 things. Why should they vote for this? Is this about more affordable housing? Is this about allowing charities to make more houses? Is it about raising property taxes? Some combination? Give us kind of that final pitch of why someone should vote for this.
So I would just encourage you that if you are like me and you feel that Georgia has an issue with affordable housing, and all of the numbers bear this out, and you talk locally to community leaders and those involved, this is a real issue. And so the choice for me was to propose something that would try and make somewhat of a difference in this space, or do nothing. And so I chose to do something. And I would encourage the voters of the state of Georgia that care and have a desire to see this issue addressed, that if you feel as I do, that you would also support this and vote yes on the referendum. And again, I appreciate the opportunity to provide clarification on it and how it works. And certainly if anyone has additional questions, my contact information is on our legislative website. I'd be happy to talk to you offline about that. But I, again, appreciate the opportunity to be with you today.
Representative Gamble, thank you so much for your time and explaining this important part of what people will be voting on here in November. I'm Raul Bally of Oconee Radio Group. Thank you to everybody at the Atlanta Press Club for making this happen. Thank you. Good afternoon. And of course, people, vote. Christy, you're muted. Sorry.
It would not be a fun day if we did not have at least one muting problem on our lives on Zoom. Sorry about that. Again, my name is Christy Wooten. I'm the president of the Atlanta Press Club. I want to thank everyone who was with us today, our moderator, Rahul Bali, our special guests, Andy Welch, Carrie Miller, and Matthew Gamble. Very enlightening, thorough discussion on the proposed amendments and referendum that are going to be on the ballot in Georgia in just a few weeks. I wanted to let everybody know today also, in addition to checking our website at atlantapressclub.org, signing up as a member, donating, or joining, I would like to say we've got several more events coming up, especially those in our Loudermilk Young series that will be of interest. Part 3 of our voter education series is on October 7th. That's the event, Voting Rights, Voter Protection, and How to Stay Safe at the Polls. So that will be on October 7th. And then the day before that, we actually have a special newsmaker event Disinformation, what every journalist should know. And that will be the AJC's Tia Mitchell in conversation with CNN's Brian Stelter. So please visit our website, atlantapressclub.org, sign up for those events. We look forward to seeing you soon. Thanks everybody for joining us today.
Thanks, everybody.